like how to start with the company incorporation, how to do the trademarks, and all that will definitely add a lot of value in your business. It encourage industrial development, and it is a very good source of. So when we are talking about patents, we often we hear a lot about lawsuits, especially big companies. Especially big companies, they will be involved in these kind of lawsuits. So this is one example of lawsuit wherein Google and Microsoft, they filed a lawsuit. There were around 20 lawsuits filed between both the companies in the year 2010. So the two companies were fighting over royalties related to the technology expo. There was a fight going on between them for years altogether, and then finally, they did outside court settlement. They joined hands. They collaborated together because they thought that both the technology, both the expertise of both the companies, or the technology and the patent pool which both the company owns, if they collaborate together, they can benefit the customer in a large scale. So they collaborated, and all the lawsuits got over. Similarly, this is one patent filed for super absorbent hydrogel. One of the agricultural institute in India, they filed this. So this hydrogel possesses water absorption potential, which was 350 times higher than the existing products, and it has wide industrial application also in agriculture and pharmaceuticals both. So, because of the great demand of this particular patented technology, the owner of the technology, which was IARI Institute, they were able to license this technology to 8 companies, and they created a very good revenue source for them, because at a time they licensed their technology to 8 companies. So again, this is one another example of NEEM patent case. So a patent was granted in Europe, Europe Patent Office. The method for controlling fungi on plant by the aid of hydrophobically extracted neem oil. So this patent was granted in 1994. But in 1995, what happened that this patent got opposed by Research Foundation for Science and Technology, New Delhi. So this was filed in EPO, and it got opposed by this particular institute in New Delhi on the basis that this is a traditional knowledge, and you cannot patent a technology based on the traditional knowledge. There is no novelty, and based on this, finally this patent got revoked. So when we are talking about patents, there are different kind of patent applications that can be filed with the Indian Patent Office. One is ordinary application, wherein we file the patent application for the very first time with the patent office. So the invention is not claimed anywhere, it is not published anywhere. So first time it is a new invention for us. So first time we drafted it and filed it with the Indian Patent Office as an ordinary application. So another is conventional application. So now what happens sometime, a client comes and they have a market in India as well as in US. So they want to protect their technology in India as well as US. So many times what they do, like first they file in the home country, which is India, and then there is one conventional route wherein you can file in the other country within 12 months, and you can claim the priority date of the first filing. That means your home country filing. So this conventional application can be filed in such scenarios. Then PCT international application. At times when the clients they want to file their patent in multiple countries, especially more than 3 countries, then we suggest them to go via PCT route. In PCT route, you can file in multiple countries by doing one filing. So this is a very good platform, PCT, a very good platform for multiple patent filing through single filing effort. You enter into multiple countries. So when we do the PCT filing, then from the PCT filing date, after 30 to 31 months of time period, your application will enter into respective countries. So that time, a respective country will examine your application, and based on the examination, they will grant the patent. Then there is another provision which is called patent of addition. So in patent of addition is a provision given by the patent office, because sometimes what happens, we file an invention with the Indian Patent Office. But after 6 months or 1 year, the inventor further developed the invention, and sometimes they come up with some significant improvement, the addition of some significant features to the existing invention. Then, in that case, instead of filing a new invention, we can file a patent of addition on the existing patent that has been filed. Then divisional application. This scenario comes when sometime application is filed with two inventive concept. So as per the Patent Act regulation, we can file patent for only single invention or a single inventive concept. But sometime if when the inventor is not aware or sometime by mistake, if a patent is filed which contains two inventive concept, then in that case your patent application will be opposed, and the controller will ask you to split your application, divide your application into two patents covering the respective inventive concepts. So that is when the divisional application filing will take place. So this was about patents. So now the other form of IPR is copyright. So when we talk about copyright, copyright never protect the idea, but it always protects the expression of the idea. As a matter of fact, for copyright, this is one kind of IPR wherein even if you do not protect your copyright legally, still the moment you create your work, if it is original, it is not copied, if you are the original author of your work, then by default, it is your copyright. So copyright provide protection to the owner for their original work. It should be original work. It should not be copied. So it can be the work can be in any form such as movie, song, articles, book, algorithms, paintings, sculptures. So these kind of work can be protected under copyright. For getting a copyright protection, the work of the author should be original, fixed in a tangible form, whether published or not published. So, definitely, you have to express it in the way of writing or in the way of painting, or sometime, your voice recorded in any software. All these kind of work can be protected under copyright. So there are several different categories which comes under copyright. One is the literary work. So under literary work, we can protect the computer programs, algorithms, compilation, databases. Such kind of work can be protected under literary work. Then dramatic work include recitation, any scenic arrangement, theater plays, dramas. So the anywhere where a work which is capable of being performed by action. So such kind of work comes under the dramatic work. Musical work, definitely it will cover the songs, the lyrics, the notes. These kind of things will come under the musical work. Artistic work will include all kind of paintings, photograph, then drawings, then even a chart. Any work of architecture will come under the artistic work. And last will be the cinematographic work, which will cover all the movies kind of work. So, as I told previously, that for copyright, it is not a mandatory requirement that you should protect it legally. Still, you possess own your copyright, but it is always good to protect it legally, because in future, if somebody copies your copyright, that time you will land in trouble. If you have legal right over your work, you can send them a legal notice. You have a backup from the government. But if you have not attained this legal protection, then in that case, there's nothing much you can do except you can request the third person to not to copy. So these are some of the copyright infringement cases which we can see. So this is how your work gets copied. You can see the original work on the left side, and on the right side, the little bit modification they have used the author's work. Similarly, here this photograph was copied and used as a front cover of a magazine. So we spoke about patents, we spoke about copyright. Now we are talking about trade secret. So trade secret is another category of IPR, and it is unique in its own way, and it is interesting also, we can say, because it is different from patents and other kind of IPR protection. Because in trade secret you are not doing any kind of legal protection. Only precaution you are taking is you are keeping your invention secret. Okay, so it can be anything. It can be a data, or it can be some information relating to your business. So it that you can keep anything trade secret which is giving advantage to your business. So you don't want to patent it, because if you patent it, it is a mandatory requirement that after certain time period your patent will get published and it will be in the public domain. So there are certain information and data which the business feels that, instead of going for a patent, they would like to keep it as a trade secret. So very good example is Coca Cola. They claim that, the formulation of this drink is a trade secret. Until now, nobody has been able to reverse engineer it, or nobody has been able to achieve the same formulation. So the benefit with the trade secret is, unlike patent, which has a fixed time period of 20 years, the time period, there's no time period for trade secret. Till the time you can keep your information secret, you can enjoy the monopoly. So, as I said, a trade secret is a unique form of IPR protection where, instead of disclosing the information to government for getting legal protection, the data or the information is kept confidential. So, any type of data, process, or information can be kept secret. There is no rules or regulation for that. So, for maintaining a trade secret, a business should have an internal process or data that is followed on everyday basis that gives an edge over its competitor. So, generally, in trade secret, in a company, few employees will be knowing, and they must be having some kind of mutual agreement among them that they will not reveal it to others. Maybe even if they leave the company, they might have some agreement, because the whole liability lies on the trade secret owner itself, like how they can maintain the confidentiality. So definitely trade secret also gives a competitive edge. It helps to succeed in the business. So another good example of trade secret is KFC recipes. So apart from Coca-Cola, even the KFC, they also claim that the recipes which they make, they have maintained trade secret for that. So this is another example of trade secret. There is one asthma treatment which is given in Hyderabad. So they give it yearly once on some auspicious day, and people have also claimed that it completely cures the disease. So this is another example of trade secret. So we spoke about patents, copyright, trade secret. So now we will talk about industrial design. So industrial design is another form of IPR protection, wherein the protection is not given to the technology, but it is given to the aesthetic appearance of the product. So if your product is new in look, if it has some appealing look or the aesthetic appearance is new, then in that case you can go for design protection. So it is given only to the shape or the configuration of the product, but it does not protect the underlying technology. It does not protect the working or functioning of the technology. It only protects the uh, uh, appearance, aesthetic appearance of the product. Then comes the trademark. So, trademark is another form of IPR protection that is generally given to symbols and words. For example, your company name or your product name or the logo of the company, the slogan of the company. All these things can be protected under trademark. So the major advantage of trademark is it helps in branding. It helps to identify your company or the goods in the market. So it creates a uniqueness or differentiating factor for the business. So for getting a trademark protection, ideally a best trademark word will be a self-coined word. It should not be descriptive like fair and lovely for a fairness cream. So this will not be considered a good trademark because it is a descriptive mark. So a best trademark word should be self-coined. For example, Kodak. So Kodak is a good example of self-coined trademark word. Also, apart from this, there are some well-known trademark which has become very famous by its usage. For example, Microsoft, Coca-Cola, Apple, McDonald's, Mercedes. These are some example of well-known trademarks. Then comes the geographical indication. So, geographical indication is another form of intellectual property right protection, wherein it is used to identify agriculture, natural, or manufactured goods originating from a particular region. So, this kind of IPR protection is also unique because it is not granted to a particular person or a particular owner, but it is given to a community as a whole. So it has why it is given if it has some special or unique characteristics that are unique because of that particular geographical area. So, for example, basmati rice. So, basmati rice is one example of GI. So, why it is granted geographical indication? Because the farmers in the Himalayan region they claim that because of the soil there and because of the climatic condition which prevails there, they can get this quality of rice. If you try to grow the same rice in some other environment, you will not get the same characteristics. So, such kind of products are granted geographical indication. So, good examples of GI will be basmati rice, Darjeeling tea, Nagpur orange, Kolhapuri chappals, then Darjeeling tea, Bikaneri bhujia. So, these are well known examples of geographical indications. Now, I think this is the last category of IPR, which is domain names. So, domain names actually they do not come under IPR. It is a completely different field, but we consider it because, as you have seen, the domain name will always include the company name or the product name or the individual name that can be subject to trademark. So now we spoke about basics of IPR. What is the need and advantage of IPR, and what kind of categories comes under IPR, and based on the kind of innovation or invention you have generated, what kind of IPR protection you should choose. So now we will talk about the IPR management for startups. So we'll talk about the relevance of IPR for startup. So we know that intellectual property has become key wealth drivers in the present era. So it is not like before, when in the past, when somebody used to start a company, the main asset would be the building or the property and the capital, those things. But now in this era, it is not like that. The knowledge, the intellectual property assets which the company possesses, these kind of things also holds a lot of value to the current companies and even the startups which are being opened. So IP can be a USP of the product or service in today's competitive and dynamic world. So, for example, a startup can have IPR asset in the form of trade name, brand, logo, advertisements, inventions, designs, products, or even the website. So there are different kind of IPR assets which a startup company can have. So, what kind of strategy a startup should have in their mind when when they are new in their business or when they are starting up with some new company? So, make intellectual property protection a priority. It means that when you start your own business, there can be n number of things in your mind. You have to take care of the capital, you have to take care of the company incorporation, you have to take care of the hirings, and you have to take care of the sale, marketing, everything. But in that process, intellectual property should not be lost. You should, at least you should have a plan, like how to you should also strategize your IPR plan, like how to integrate it with your business plan. Because initially, if you will miss it, later on it can be a problem. Because for startup, capital is always a major concern. So sometimes, to take financial help, when you go to investors and when you pitch your business plan to them, along with that, if you have some IPR protection also, then it adds lot of value. The valuation of your company goes high. Also, the same thing applies at the time of exiting. Suppose a startup, for any reason, if they decide to exit and they decide to close the company, that time also, for merger, for selling of your company, if you have certain IPR protection in your hand, it will help in a greater way to valuate your company. The investors will find it very easy to valuate your company. Then, see, whenever we are talking about IPR, we should not think that it is only a mean of expenditure. It's never like that. If you have good IPR in your hand, like good patents, valuable patents, then you can even even if you don't have the means to manufacture it, or bring it to the market, you can always license it, you can always sell it, and you can get a good amount uh, out of it, and that can be one good revenue channel for a startup. Then, register intellectual property rights. So, whenever we are telling to a startup that you should register your IPR assets, it is not necessary that initially only they should, go for all the filings and they should allocate a, big financial budget for IPR. It is nothing like that. You should always assess, like there can be multiple IPs which a startup can have. They might have some copyrights to be done for their manuals, for their presentations, website. Then they can have some good technology. If it is a technology oriented startup, they might have some very very good unique technologies which deserves patent protection. So trademark will also go hand in hand, protecting your company name, logo, slogans, your unique products. But you should prioritize, you should understand that what kind of IP protection is more important for me, what I should protect now and what I can do it later when I will, when my startup will start generating more money. Also, when you are thinking about patent, you should always think that, which areas, which countries are my primary market. Based on that, you should decide on the patent filing. Also, the timing, as I said, you should not jump into it. It is not necessary that, initially only you have to protect all your IPs. You can always think whether at the time of conception of the idea only it is important to protect it, or you can wait, you can wait for the prototype to get developed, see the response of the market, and then do it. So all these, there are different questions which, you should assess, and then go for the IP filings. Then due diligence of intellectual property rights. It is very important because even when I'm talking about it is very important for a startup to protect their IPR. At the same time, it is very important to understand the IP which your competitors possess, because it should not happen that you are copying somebody's else your competitor's IPR, or you're infringing on them, because that will also land you in trouble. So you should have proper knowledge about IPR at the very beginning. You should do proper due diligence that you are in the safe zone, you are not infringing anybody's IP rights. Then you should assess what kind of value your IPR protection is adding to your firm at this moment, and based on that you should devise a IPR strategy for your business. Then another important aspect to be considered is agreement. So whenever you are generating a lot of IPR assets in your company, and you are not only dealing with your employees, you are also dealing with outside vendors, you are also dealing with some other third party. So you should have proper agreement in place. You should have proper NDAs and mutual agreements in place with your vendors and your employees, so that none of your IPR assets are exploited in future. So every company, every startup should have well drafted NDAs and agreement in place. They should also have well drafted IP policy that each employee is following, so that it should not happen that the IPR assets of a startup is getting copied, or is being filed on somebody's other name. So all these kind of precaution a startup should take, so that in future they will not end up in trouble. So, what are the common, mistakes which a startup do? So, the common mistakes will be like ignoring IPR. So, there will be a category of startup who are not at all paying attention to, what should be their plan and what all should be protected. They are completely ignorant about their own IPR assets which they have generated. Other will be too much IPR. As I told you, there will be time when one product of startup will be, can be protected via, for example, phone. If you have developed a phone, so there can be a case that that phone, you can protect it via patent, you can protect it via design, you can even protect it via copyright, because the technology will go under patent, the manuals will, the code, the algorithm will go under copyright. If there is some unique user interface, it can go under design. The name of the phone can go under trademark. So there are n number of things which you can protect. But for a startup, it is not necessary to jump into it and go for start all the filings and spend a lot. So you should always think, you should consult your IPR attorney, and based on the market scenario, based on the competitor analysis, you should take proper steps. Then careful with public disclosure. As I told you, you should have proper agreement in place. And also, if you're planning to go for a patent, not now, maybe after 6 months down the line or 1 year down the line, then you should not disclose your inventive concept in a workshop, or to any vendors or third parties, because that can also act as a prior art for your own invention at the time of the patent filing. So that's why you should take all these proper precautions. You should have all these in form of some IP policy, so that everyone is aware in your business how to take it, how to go about it. Then, as I already mentioned, proper agreements with vendors and employees. So now, as so many startups are coming up, and so that's why government is also motivating the startups, for which they have come up with many schemes also, which the startup can utilize. For example, SSIP, Startup India Initiative, and Make in India. Then expedited examination available for startups. So this is one provision wherein the startups, the patent application which will be filed by startup, they will be examined in a fast track manner. So even we have witnessed that past couple of years we filed few inventions for startups, and we availed this expedited examination provision. So the patents are getting granted within a year, and vice versa, if you go via standard route, it takes minimum 2 to 3 years. So these are some very good benefits, which the government is offering to the startups. Then discounted filing fee. So for startups, they are giving 80% rebate in the patent filing fees. Then support for international patent protection. So generally, Indian patent filing will not be very costly, but when you will go for international patent filing and PCT protection, so that kind of filing will require a lot of finance. So government is also supporting international patent filing for startups. Then accelerating growth of new India's innovation. There is another program called Agni. So under Agni, the government is not only helping the startup to get a patent, but it is also helping the startup to commercialize their product in the market. So they help to sell your patent. Sometimes they help to license the patent. So there are different kind of benefits offered by the government which the startups can avail, and they can strategize their innovation and IPR protection journey. So, what are the main advantages which IPR provides to startups? One is prevents copying. So, for startup, initially the technology and the funding, everything will be limited. So it might happen that the startup is running on purely on core one technology. And what if in future you get to know that some big player, they already copied your technology, and and now you can no longer use it. So that is why you should take proper due diligence at the beginning itself. Then brand identity, product differentiation. So trademark is very key integral part of any startup, or I would say any business, because when you start the business, that time you might not recognize the value of trademark. But as the company grows, the company name, the logo, everything becomes the face of your company. And if any infringement or copying happens there in future, it can be very detrimental to your business. So that's why you should do these kind of due diligence at the very beginning. Then identify future research growth areas. So there are different kind of provision under IPR, like landscape analysis, in which you can completely track the activity of your competitors, or activity patenting activity with respect to one particular technology. So that help you to know the gray areas or the open areas wherein you should spend in the research. So when you are aware about these kind of information, when you have these kind of data at the very beginning before you even start investing in your R&D, then it helps a lot in doing meaningful investment. You have a better better opportunity to grow in that area. So basically it helps in meaningful investment in R&D and D and better utilization of the resource. And apart from that, I already mentioned that there are this IPR, you should not consider it as a only source of expenditure, but it can also act as a very good source of revenue if you are able to commercialize your patent via selling, licensing, franchising, or any other means of IP transactions. And I also discussed this point that IPR assets help in valuation while obtaining finances from investors. So these are the uh, different advantages which you get by utilizing IPR. So this is it. I have covered all the points here. So if any doubts or anything, any questions, you can please let me know.
Yes, ma'am. Thank you, ma'am, for this wonderful and informative session. So,
Thank
ma'am, we have some questions
you.
related
Sure.
to the IPR management. So, the first question is copyright is good as it can help to invent new thing from previous one?
I didn't get your
Sometimes,
question, dear. Sorry. Can you
yes,
repeat?
ma'am. Yes, ma'am. Yes, ma'am. Sure. Is copyright is good as it can help to invent a new thing from previous one?
It is again not clear.
Okay, ma'am. I'm repeating once. Is copyright is good as it can help to invent a new thing from previous one.
See, it is nothing about, good or better. It always depends upon the nature of innovation that you are doing. So, if you are Hello.
Yes, ma'am, it's audible now.
Yeah, am I audible now?
Yes, ma'am, yes, ma'am.
Yeah, sorry, my I got reconnected. There's some problem with the internet connection. Any other question?
Actually, voice is breaking.
I cannot hear you.
Hello, ma'am. May I ask more questions?
सुनो, कनेक्ट हुआ, आवाज ही नहीं आ रहा है। वो लोग सुन ही नहीं पा रहे मुझे। वीडियो बंद है, देखो। हेलो।
Yes, ma'am. Ma'am, may I audible?
Yes, now I can hear you. You can hear me now?
Yes, ma'am, yes, ma'am.
Okay. Okay, sorry for the interruption. Yeah, please tell me any other question.
Yes, ma'am. Ma'am, there is one more question. What
Yeah.
to do if someone has copied our invention?
See, if someone has copied our invention, at what stage, it depends on that. If we have already filed a patent, then legally we are the owner of that invention. So if somebody copies it, then legally we can send them a sue notice.
Okay, ma'am.
So we can
Thanks,
send them
ma'am.
infringement
Ma'am,
notice.
yes, ma'am. Ma'am, there is last question. Can
Yes.
we feel patent for any invention?
Can we
Feel patent for any invention?
feel patent for an invention?
Yes, ma'am.
I did not understand your question. Can you, reword it? Or you can also mail me your queries also later on. That is also fine. Yes, definitely we can file patent for an invention. So as I already explained, depends on the nature of the invention. If there is some novel technical element present in your invention, then we can file a patent for it.
Yes, ma'am. And now I would like to invite Dr. Anita Mahajan ma'am for vote of thanks. Please, ma'am.
Hello, am I
Yes,
audible?
ma'am. Yes, ma'am. Properly audible.
Yeah. Thank you very much. Good afternoon to one and all present here. It is an honor for me to get the opportunity to thank you all the dignitaries present here. So, on behalf of Computer Science and Engineering Department, to Miss Tanu Singh, Ma'am, Entrepreneur, Indian Patent Attorney, Startup IPR Facilitator, Intellect Vidya Solutions, for her time and contribution to make this session a great success. Thank you, ma'am. I would like to
Thank you
extend
so
my
much.
okay. I would like to extend my gratitude to Acropolis Management. A big thanks to our director, Dr. S.C. Sharma sir, and special thanks to Dr. Kamal Kumar Sethi sir, head of Computer Science and Engineering Department, for providing immense support to make the event successful. I would like also to extend gratitude to Mahen sir and the student team who systematized the workshop on such trending and ambit area. Heartily thanks to all the participants to make this session successful. Thanks again. Thank you.
Thank you so much. It was great to be here again and share my IPR views with respect to startups. I hope everyone will be able to benefit from this session. And I have dropped my email ID in the message. So if you have any queries or questions with respect to IPR, you can definitely reach me back. Thank you so much.
Thank you, ma'am. Thank you very much.